Good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case today. We have one case set on the docket at 10 a.m. Also joining me on this panel is Judge Jim Edwards from Seminole County and Judge Meredith Sasso from Orange County. I'm going to assume that the appellant would like to reserve 5 minutes unless you tell me differently for rebuttal. And
Yes,
I would
right.
just ask for everyone to please keep their noise-making devices silenced so that it doesn't create any disruption when a party is putting on their presentation. And the appellant may begin.
All right. Good morning. The first issue that we're dealing with in the appellate brief, our argument is that the appellant was affirmatively misadvised that a surveillance video from the Titusville Aldi's, which he believed, I believe reasonably, contained advantageous and potentially exculpatory evidence, would be presented at the Williams Rule hearing and at his trial, and that he did not learn that this video did not exist until after his misinformed rejection of the state's final plea offer.
And counsel, what was the potentially useful information that did you proffer to the trial court what that evidence would be?
I believe the testimony obviously we have a sworn motion as well that I believe is part of the record. I believe the case law would say that would be record evidence as well that was sworn to by Mr. Stanley. But the physical stature, the movements, the gait of the person, the clothing description, all of those things Mr. Stanley, the appellant, believed were different, and that he was never dissuaded of this belief by his trial counsel at the time. And I believe it was conceded that the trial counsel, that the appellant had believed that after he'd watched the Rockledge video, that there were physical differences between the robber depicted in the Rockledge video and how appellant appeared at the Titusville Aldi's video.
And that your client was on trial for the alleged robbery that occurred in Rockledge, correct?
That is correct.
This video was the subject of the Williams Rule hearing that the court ultimately denied as it concerned the Titusville Aldi robbery, correct?
That is accurate, yes.
Okay, all right. And so after the hearing, the Williams Rule hearing, the case proceeded to trial in the Rockledge case, correct?
Correct. We
Okay.
proceeded to trial after that. And again, the record's clear during that hearing, the Williams Rule hearing, is when Mr. Wagner, the trial counsel, realized that Titusville Aldi's video did not exist and said he was just going to have to kind of shoot from the hip during that process. And again, this is after the last offer had been revoked. And obviously, I understand Counsel Wagner testified at the evidentiary hearing that Mr. Stanley did not want him to pursue any further offers after the rejection of the Williams Rule or the denial of the Williams Rule motion. Well, actually, I guess it was granted for the state, but after a negative ruling for the appellant. I don't believe that that's credible, and the reason I don't is if we look at the letter that Mr. Stanley sent, and it was part of volume 1, page 220, he's indicating in there that he would accept a best interest plea, and this is at the time when he believes that there's a advantageous video, this Titusville Aldi's video that he's written about, and he notes differences in that he believes that there's differences between these videos that he can show would be at least something he could argue, if not completely exculpatory. So he says he'll accept 3 years in each case. It doesn't clarify consecutive or concurrent, but he testified at the hearing, which is uncontradicted, that he meant he'd accept 3 + 3. He said he would be a reasonable resolution. He wanted to get it over with. So to say that he would not, after finding out that that video doesn't exist, that he would not want to try and go get that 10-year offer, I don't believe is credible.
Well, counsel,
Sure.
Are we allowed to reevaluate the credibility? Are we allowed to go behind the trial judge and say, look, trial counsel, if we accept your argument, trial counsel bungled the video being in existence, bungled the minimum sentence, whether it had to be consecutive or concurrent, and to kind of save his hide, if you will, he goes, well, by the way, when I asked him if he wanted the me to try to get to 10 years. Are we really allowed to do that at this stage?
I believe if it's clearly erroneous and the facts, there's not sufficient facts to support that finding, I think the appellate court can. And I believe based on all of the testimony, if you look at the full context of Mr. Wagner's testimony, he has very limited memory as to much of the interactions with Mr. Stanley, yet has a very vivid memory of this specific interaction, which I believe that is not credible. And I think that's something the court can evaluate to determine whether there is a sufficient basis for this factual finding by the trial court.
Well, I mean, what about the specific finding that the defendant's testimony was not credible on certain issues? How do we determine that that's, to use your phrase, clearly erroneous?
I understand what the court's saying. As far as I don't know if the trial court, and I don't have that order in front of me, if the trial court specified what it found specifically that Mr. Stanley testified to wasn't credible and what it found that Mr. Stanley testified to was credible. I do know that based on this, contemporaneous written communication, attorney-client written communication that was admitted into evidence, we have evidence that he said he would accept 3 and 3 on each case. One case was a slam dunk for the state that I believe he testified to. And I don't think there's any debate as to the Titusville case being him clearly guilty of carrying a concealed firearm. I don't think there's any debate about that. So he was willing to accept 3 and 3. Obviously, his testimony that totaled 6 years, that's the only evidence that we have. There's nothing to contradict it. Mr. Wagner did not say or testify at any point in time that Mr. Stanley said no, 3 concurrent. And I don't believe there was a specific factual finding by the trial court that he found that Mr. Stanley, the appellant, was not credible as to that specific testimony. So I believe that would address that. It's our contention that, if he had been aware, Mr. Stanley had been aware that this did not exist, and it was pretty clear, and I don't think it's controverted, that he believed this was a primary feature of a misidentification offense. If he did not know that did not exist until after the office revoked, that's problematic.
Was there any evidence that tied the gloves that Mr. Stanley was wearing in, was there any tying to the 2 separate incidents? And also, I believe the gun had some distinctive markings on it that Mr. Stanley was found to be in possession of. Was there
Yes, Your Honor.
evidence tying those to both all the robbery scenes?
Yeah, yes, Judge. I'm glad you brought that up. The gloves, supposedly, there was testimony that they were very distinct. They had distinct lettering on, I believe, the knuckles of the gloves. Mr. Stanley testified that he did not realize when he watched the video the one time, and I believe the testimony was that he watched it one time from counsel and Mr. Stanley, that was going to be testified to, that these gloves are going to be so closely linked together, the gloves that he was found to be in possession in Titusville of, and the gloves that supposedly identified by, I believe it was Mr. Barker in the Rockledge Aldi's robbery, where he says, I saw the lettering on them. And then, obviously we have the lettering on the gloves found. That goes towards the issue 3, but I think that is an important point, is that if you look at the contemporaneous attorney-client communications, he doesn't reference that at all. He just references gloves. He doesn't reference any writing on them, doesn't reference anything related to any distinct writing that would link the 2 together. I think he might even, and I don't have that specific exhibit in front of me, but I believe he might have even referenced it as just gloves versus, no gloves. So additionally,
Counsel, I do have it in front of me, and he, on his list, he has black gloves for both robberies with a little plus sign, meaning they're similar.
Okay.
According to his legend. So
that's probably correct. And if you have it in front of you, I would defer to the exhibit. So yeah, I mean, I think he acknowledged that there was gloves. I don't think he knew to the extent that they were going to be identified down to the lettering on the knuckles, which is very distinctive and pretty strong evidence, obviously, linking these 2 events together, having these 2 very specific, distinct features on these gloves. So you had mentioned the gloves. You'd also mentioned the firearm. There was testimony, and again, this is more towards issue 3, but there was testimony that the firearm had specs, I believe, on it. That was Mr. Barker's testimony from the the Rockledge Aldi's robbery, and that the gun that was recovered from Mr. Stanley on the Titusville incident did not have these specs. And obviously that was a distinction. And then that comes out, and we thought that was kind of a clunky way of it coming out. It could have been handled through cross-examination and impeachment, but instead they end up playing the whole statement, including other things that the state was able to use, including the fact that there was supposedly a comment that he had robbed every Aldi's from New York down to Florida. Then we have testimony, obviously, that Mr. Stanley is from New York, and the state was able to link that together. So by opening that door, instead of being more precise and just impeaching as it relates to the very specific identifying features of the firearm, the whole statement was admitted in, and the state was able to use things from that statement against Mr. Stanley. I'll move on to point 2, which is that the trial court erred when it disregarded clear record evidence that the appellant was misadvised by trial counsel as to the minimum possible sentence, which resulted in his misinformed rejection of a reasonable plea offer. In this case, and it's very clear that Mr. Stanley and Mr. Wagner trial counsel had conversed about this, and he was advised that the 10-year minimum mandatory on the robbery with a firearm was his minimum possible sentence if he was convicted at trial. I believe trial counsel, even at the hearing, said, yeah, he told him that, and he believed that that was correct. I don't believe, based on the case law, that is correct. I believe because there is non-qualifying and qualifying offenses charged in the information, the non-qualifying would have to run consecutive to the 10-year min-man on the robbery with a firearm count 1. So he was misadvised as to his minimum sentence. I believe if you calculate it out, that his minimum sentence actually would have been 19 years. So if he had known that, it's our contention that he would have accepted the plea offer. If he had known that and the issue with the Titusville Aldi's video that he believed to contain exculpatory evidence potentially, if he had known those two things prior to his final rejection of the offer, he would have accepted it. And I don't think that.
How's that clear from an appellate standpoint when there's testimony that he was not interested in serving 10 years?
Well, I think I think you can extrapolate, and the reason I'm saying this is when we have the evidence that he would have accepted some offer. We have the evidence, and again, that's through his written communications. We have evidence that it would have been 3 and 3. He testified it would have been 6, and 6 and 10, not that big of a leap. And again, this is when he believes that there's potentially exculpatory evidence. This is when he believes that his minimum sentence is 10 years. When he's writing this letter to his counsel saying he's willing to take a best interest plea because of all these other things dealing with his child and his wife and situations external to him, that he was willing to resolve the case. So, it's not that he was steadfastly against resolving the case. We know that that's not the case. That was how it was characterized by Mr. Wagner, is that Mr. Stanley just didn't want to accept pretty much anything. But we know that's not accurate from the contemporaneous written communications between attorney and client while the case was going on, and they were admitted into evidence. So I do believe
it sounds to me like, from the argument that you have now presented to us this morning, that the triggering event that you believe would have resulted in him wanting to accept the 10-year offer from the state was the misrepresentation with regard to the maximum minimum sentence that he would have been facing. You said just now, just a few minutes ago, that had he known that the video didn't exist, and had he known that there was, the potentially misrepresentation with regard to the minimum sentence, he would have taken that offer. So it sounds to me like you're almost qualifying it, which leads me to believe that maybe the issue of the missing videotape wasn't such a big deal. And the example of that was the fact that he, at least according to his attorney, he rejected, or he did not engage or accept his attorney's offer to reapproach the state about the minimum offer once it was officially represented to him that there was no videotape. Is that accurate?
Judge, if I was not intending to qualify it, I was intending to say more of a cumulative effect. I think on either ground, the missing video that he believed contained exculpatory evidence, I think alone he would have accepted if he had known. That was the primary feature of his misidentification offense. He wrote numerous writings to his attorney at the time, addressing the differences between the two videos, referencing that numerous times. That was obviously what he believed to be the primary feature. I think that on its own shows that he would have accepted if he'd known that didn't exist after he rejected the final offer. I did not mean to qualify it. It was my intention to say, yeah, we have that, and we have the fact that he was misadvised as to this minimum sentence, which is not the 10 years, which would have been 19 years if he's convicted at trial. And obviously I raised the case of, and I have in front of me Mongo, and a little bit different facts, but I think it bears review in the fact that Mongo, well, I have 5 minutes left. I'd like to reserve it for rebuttal. Thank
All
you.
right, you may. Ms. Williams may proceed.
And good morning. My name is Alyssa Williams, and I represent the state of Florida. May it please this court and opposing counsel. In regards to issue 1 raised in this appeal, the state's position is that competent substantial evidence supports the trial court's findings that counsel was not deficient. And I wanted to read, to answer back to Judge Sasso's question, the trial court's specific findings on credibility regarding the defendant and Mr. Wagner, and this is on page 283 of the record. The trial court stated many of the issues the defendant complained about in his motion are based solely on semantics or minutia. It is clear the defendant was very much in charge of his case, and his current allegations are evidence of buyer's remorse in turning down the state's plea offer and proceeding to trial. The defendant never asked Mr. Wagner to approach the state for a new plea offer after the Williams rule hearing, and instead chose to go to trial and take his chances.
Ms. Williams?
Yes, sir.
I believe Mr. Wagner at some point during the post-conviction discovery evidence and hearing admitted to the court that initially he represented that there was a videotape of the Titusville Aldi event and that he had in fact reviewed that videotape. Is that correct?
Yes, he did state that in the evidentiary hearing. However, later on in the evidentiary hearing, counsel also testified that the differences and similarities that were in the 2 videos came from other sources, such as like the police report and other documents turned over in discovery.
I understand that, Ms. Williams, but I think, isn't that a pretty big misstep by the attorney in this case to say, I have seen the videotape, I have reviewed the videotape, and then later come back and say, the videotape doesn't exist? That's a pretty big deal, don't you think?
In this case, at the evidentiary hearing, counsel Wagner testified that he was able to get what he considered to be the issues of importance.
I understand that. I understand that. But to a non-legally trained person who is accused of a crime where is told there is a videotape, and the videotape, if the person was there, would depict what they looked like at the time, for the attorney, the trained legal mind, to say the videotape is there and I reviewed the videotape, then to find out there is no videotape, that's a pretty big deal.
Yes,
Wouldn't
Your
you
Honor.
agree?
It could be, yes, Your Honor.
That could be very prejudicial.
It
Could
could,
be, correct?
it could be, yes. And I think it's important to note that this Williams rule hearing in the trial happened the same day. Jury selection happened after the conclusion of the Williams rule hearing. They were in trial posture where appellant was facing a life sentence. And after he discovered that this video didn't exist, Attorney Wagner testified that he offered to go to the state and re-engage in plea negotiations. And this appellant told him no and wanted to proceed to go to trial. If Your Honor still have any questions, I'll move on to issue 2. For issue 2, the state's position is that the face of the record demonstrates that appellant cannot establish prejudice because the appellant cannot establish the first prong of Alcorn, and that he would have accepted the 10-year offer. There's testimony from the evidentiary hearing stating that appellant did not want to take the 10-year offer. He did not want to serve 10 years. And I would note that the offer was for the 10-year minimum mandatory sentence. And regardless of whether he wanted to take 3 or 6, minimum mandatory is day for day. And that would be a big difference if it was 3 and or 6, day for day, 10 years. And then in regards to issue 3, which was raised on appeal, which is just the various points of evidence that appellant felt were either not represented or he wasn't informed. The state's position is that appellant has failed to demonstrate deficient performance in this case, as the contemporaneous writings of appellant demonstrate that he was very much involved in this case and he was very much aware of the evidence against him. If your honors don't have any more questions, the state would ask that you affirm the trial court's order denying the motion for post-conviction relief in all respects. Thank you.
Thank you, Mrs. Williams. And counsel, you've got, I think it's a little under 5 minutes, so you may proceed.
All right. I believe where I left off is I was referencing the Mongo case, and this is the issue 2. In Mongo, there was no evidence, unlike Mongo, there was no evidence that the appellant had rejected the plea offer because he perceived it to be the equivalent of a life sentence. Mongo was 62. The record shows Mr. Stanley was 36. Unlike Mongo, there was no evidence that the appellant believed a key witness would not show up at trial and testify. There was no indication to that. So we have a situation where, Mongo is misadvised, but they found that it was harmless error because he wanted to go to trial for these reasons that don't exist in this particular case. I believe we satisfied all the Alcorn prongs. The state argues that, he did not want to accept the 10 years. There was clear evidence he did not want to accept the 10 years. But we have to look at that. We can't look at that in a vacuum. We have to look at that with context. He did not want to accept the 10 years at any point in time when he believed that there was a video that was going to potentially help him win the Williams rule hearing, that he believed a video that had potentially exculpatory evidence that even if he didn't proceed and win the Williams rule hearing, he could use it at trial. He believed that his minimum sentence was 10 years, and when in fact it was 19 years. So if we're looking at it in a vacuum, yeah, there was evidence he did not want to accept the 10 years. If we're looking at it based on what was he informed, he was misinformed. This is a misinformed rejection of that 10-year offer. And that's the real problem that we have here. And we have evidence that he would have accepted an offer, and it would have been a prison offer. So I do believe that the court can take that into consideration to evaluate the credibility of whether he would have, in fact, accepted a 10-year offer had he been properly advised about the video or the fact that it did not exist, and if he had been properly advised about his minimum sentence. As it relates to point 3, I'll just kind of hit the main points. There was a number of different things that Mr. Stanley indicated that he was not aware of that came out at trial. We're dealing with the Kip Potchin and Arnold Pugh testimony. It did come out that Mr. Stanley was aware of their existence. He being a lay person, I believe the court previously pointed that out. He believed that, I believe Mr. Pugh was a Williams rule witness. I don't think he understood that means he could also be used at trial if the Williams rule proceeds forward. But
Counsel,
regardless,
which of those items that you're referencing as far as issue number 3 were not addressed in any of the letters that your client authored to Mr. Wagner during the course of discovery?
let's see. As far as
I've got the existence of witnesses, Pugh, Potchin, Romer.
Right. And I
Surveillance.
believe that, sorry.
Go ahead.
Yeah, and I believe that was addressed, and I think that was referenced, and obviously he was cross-examined on that. And I think he explained, well, I thought Pugh was a Williams rule. I didn't know what Potchin was going to testify to. Neither of them were deposed ahead of time. He believes, or he testified that he doesn't believe that Mr. Wagner ever showed him the content of that testimony. There's the issue with the lettering on the gloves, which is clear. He just says gloves, that they're similar, but he doesn't say anything about the lettering or knowing anything about distinctive lettering. He just says, I think, as Judge Edwards said, brown gloves or dark gloves being similar. So he noted that they were similar. Then there's the issue of the northern,
the accent. How about that?
yeah, the distinctive northern accent that was discussed between he and Mr. Wagner is bringing forth evidence of that, maybe playing a recording of his voice to demonstrate his distinctive accent, because a witness had testified that there was no distinctive accent that the robber had. Trial counsel forgot to raise that issue on direct examination of Mr. Stanley's father, who probably could have been the only person they called as a witness that could have testified to that. And then that he was barred on redirect because it was outside the scope. And then we have the discrepancies in the identification of the gun, which we had previously addressed, the specs on the gun versus no specs on the gun, according to Mr. Barker. The issue with the New York comment coming in during the impeachment of Mr. Barker when they played the entire video. We have the hand dominance issue. The testimony was that Mr. Stanley only watched the video one time, and that during watching it, they had discussions that it appeared that the robber was using his right hand for much of the event. Then it goes to show you play out the whole video and he's using his left hand for a number of different things. So that came back to bite them. They end up making a big deal about this hand dominance thing, and it really had no teeth to it. The argument ended up backfiring. The state used it in a closing argument. We have the issue with the personnel file, with the comments in his personnel file being talking about the deficiencies with the closing procedures, and then the issue with the bandana and the cloth. I'd ask the court to, at this point in time, to reverse the trial court's order denying the 3.850 motion. Thank you.
All right. Thank you, counsel, for your arguments, and we are adjourned. Have a great day.
You as well. Thank you.